Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. Should the law be clear? Should the law be easy to understand? Should anything with criminal consequences be at least clear enough to let somebody know when they cross the line? I think most people would answer yes to those questions, and for the most part, federal law is that way. When you look at the mail fraud statute, for example, it clearly spells out what conduct is prohibited, even if it is one giant long run-on sentence. It says, whoever having devised or intending to devise any scheme or artifice to defraud or for obtaining money or property by means of false or fraudulent pretenses, representations, or promises, or to sell, dispose of, loan, exchange, alter, give away, distribute, supply, or furnish, or procure for unlawful use any counterfeit or spurious coin, obligation, security, or other article, or anything represented to be or intimated or held out to be such counterfeit or spurious article for the purpose of executing such scheme or artifice or attempting to do so in places in post office or authorized depository for mail matter, any matter or thing, whatever to be sent or delivered by the postal service, or deposits or causes to be deposited, any matter or thing, whatever to be sent or delivered by the private or commercial interstate carrier, or takes or receives therefrom any such matter or thing, or knowingly causes to be delivered by mail or such carrier according to the direction thereon, or at the place at which it is directed to be delivered by the person to whom it is addressed, any such matter or thing shall be fined under this title or imprisoned not more than 20 years or both, if the violation occurs in relation to or involving any benefit authorized, transported, transmitted, transferred, dispersed, or paid in connection with a presidentially declared major disaster or emergency, or affects a financial institution, such person shall be fined not more than $1 million or imprisoned not more than 30 years or both. Whew, what a mouthful. But you know, if you read through that statute and parse it carefully, exactly what constitutes the crime of mail fraud. There is no ambiguity in it. Now, the same thing applies to Medicare kickbacks and things of that nature. The law marks out bounds with clear and bright lines. And that's the way you expect it. You need to know where the guardrails are so you don't go past them. And that's just common sense, and it's also just fair notice under the notice principles of due process. Now, you'll remember a few weeks ago we talked about the Chevron deference issue and how that's now kind of a dead letter after the Supreme Court's decision. Agencies get to interpret the law, but they don't get to rewrite the law. That's Congress's job, and if they don't do it, it doesn't get done, and the agency can't do it for them. Today we're going to look at a case out of the 8th Circuit Court of Appeals in St. Louis. It's an interesting case with a little flavor of the Loper Bright Chevron issue thrown in there, and an even bigger flavor of deliberately vague rulemaking that put people at risk of going to prison for decades. As you probably realize from having seen it in the media, Tunnel to Towers Foundation, and everything like that, a lot of folks come back from wars badly maimed. They're missing arms and legs, feet, knees, all kinds of things. But you know, for somebody who was a hunter before they went to war, the loss of an arm makes it very difficult for them to hunt because with only one arm, all you can shoot is a pistol. And if you're hunting for something like deer or coyotes or some other sport hunting, and a pistol is all you're left with, you're probably not going to have a very good hunt. Well, an enterprising company called SB Tactical saw all these disabled veterans as a marketing opportunity. That sounds kind of crass, but the fact of the matter is, being successful in business boils down to finding a need and then filling it. And basically, they found a need and they filled it. They said, what if you could design a device that made it possible to shoot a rifle like a pistol? Would that not be a really great thing? So they went to work engineering a device that could make it possible for someone to shoot an AR or AK platform firearm with only one arm by using a brace instead of a stock on the firearm. To make the rifle balance out and be able to control it, it required a shorter barrel. such that the device could be described as a pistol rather than a rifle, because the difference between pistol and rifle comes down to barrel length. Now, before they could do that, they had to get ATF permission to ensure that by creating a firearm with a shorter barrel, the device wouldn't be classified by the ATF as a short-barreled rifle. Short-barreled rifles were outlawed by the National Firearms Act and Gun Control Act in the 1930s because of one particular short-barreled rifle, the Thompson submachine gun. The 1930s era law put machine guns and short-barreled rifles on the same footing. It made them expensive. It regulated them, requiring tax stamps and permission from the Attorney General to own one. And it imposed really stiff penalties for people who owned them without the proper authority. Thanks, Machine Gun Kelly and Babyface Nelson. You've screwed it up for the rest of us. So the ATF in the 1990s looked at these pistol brace devices, and they said, you know what, we think these are pistols, not rifles, because they're not designed to be fired from the shoulder. From that, thousands of pistol braces were born, and lots of disabled sportsmen were able to get back out there in the woods and go hunt. But unfortunately, that's where things went wrong. Because just because a pistol brace was designed to be fired one-handed, nothing kept someone from using the brace as a shoulder mount and thereby creating a short-barreled rifle. In addition, nothing restricted the sale of the devices to the handicapped or people with disabilities that might have the most sincere need for them. So gang members, common criminals, and other people bought these platforms and used them as short-barreled rifles, and thereby thumbed their noses at the ATF. Star note, it is never a good idea to thumb your nose at a federal agency that can put you in prison for decades. So the ATF, under the Biden administration, sought to rectify that. Recognizing that they'd let the camel's nose under the tent with the initial ruling, they now wanted a do-over. Over the next couple of years, they proposed all manner of different rules, including a worksheet with a point-based system for classifying a brace as a brace and not a rifle. And each of these interim rules were met with comments and objections, and they basically said, none of this works. You're not going to be able to tell what's a pistol brace and what's a rifle. So at some point, the federal government threw up its hands and said, okay, we'll come up with a different methodology. So they set up this rather complex system of classifying these devices, and the final rule went into effect, and no one could tell, based on the rule, whether a pistol brace they owned was in fact going to be legal. After the final rule's publication, the ATF gave possessors of braced weapons until May 31st, 2023, which was 120 days, to choose one of 5 options. Remove the firearm's short barrel and attach a 16-inch or longer barrel. Register the weapon with the ATF as an NFA firearm, paying the applicable tax. Permanently remove the weapon's stabilizing brace. Surrender the weapon to the ATF, or destroy the weapon. Not exactly a whole host of really interesting or good solutions. Anyone possessing a braced weapon who did not exercise one of those options would be in violation of the National Firearms Act, against whom the ATF may take enforcement action. And the best part, the ATF theorized that under this new definition of rifle, approximately 99% of pistols with stabilizing braces would be classified as rifles. So the regulatory markers and standards were so vague, it was impossible to tell whether any pistol brace would pass muster, and thus the only thing a reasonable person could do was get rid of the pistol brace if they wanted to keep the firearm. Numerous plaintiffs in several states sought injunctions to keep the regulations from going into effect. One group in Texas and one group in North Dakota were both successful in getting their issues into court. In Texas, the federal court vacated the ATF rule, essentially struck it down, said it no longer existed. And of course, that's been appealed to the Fifth Circuit by the government. In the North Dakota case, the opposite happened. The district court denied the injunction, making the specific finding that the coalition of plaintiffs who brought the lawsuit was unlikely to succeed on the merits. The case from North Dakota was recently decided on appeal by the Eighth Circuit. Now, the opinion is a law nerd opinion, which means people like me love reading this opinion. It's a good opinion. It's well written. It goes through the whole history of the National Firearms Act and the Gun Control Act, and it spells out the Administrative Procedure Act's procedural hurdles that the plaintiffs had to get past. And then it looked at the way the ATF rule worked. The ATF rule adopted a two-step, multi-factor framework for evaluating whether a braced weapon was objectively designed and intended to be shouldered. At the first step, the ATF says we're going to look at whether the weapon is equipped with a stabilizing brace that provides surface area that allows the weapon to be fired from the shoulder. If so, then the ATF is going to examine 6 other objective design features and factors that indicate whether the weapon is designed, made, and intended to be fired from the shoulder. Those other factors included 1, whether the weapon has a weight or length consistent with the weight or length of similar designed rifles, whether the weapon has a length of pull that is consistent with similarly designed rifles, whether the weapon is equipped with sights or a scope with eye relief that require the weapon to be fired from the shoulder in order to be used as designed, 4, whether the surface area that allows the weapon to be fired from the shoulder is created by a buffer tube, receiver extension, or any other accessory component or other rearward attachment that's necessary for the cycle of operations. 5, the manufacturer's direct and indirect marketing and promotional materials indicating the intended use of the weapon. And 6, information demonstrating the likely use of the weapon in the general community. So let me break that down for you a little bit. Basically, the ATF is concerned with whether or not you could put it up on your shoulder and shoot the rifle. And they're looking at all of these factors, and if you don't understand gun terminology, none of that makes any sense to you, and that's okay, because it doesn't have to. Because the ATF has created a rule that is simply unworkable. As you might guess, these factors are so amorphous that it was impossible for anyone to determine whether or not their pistol brace fit the requirements. And of course, the ATF had already said that 99% of the pistol stabilizing braces would be classified as rifles. So they essentially wrote a rule that completely removed the stabilizing brace from being an effective device to help disabled shooters. And that was their intent. So the Eighth Circuit looked at this from the standpoint of whether the court should have granted a preliminary injunction and whether it was right to conclude that they were unlikely to be successful on the merits. In order to get an injunction, just to review, you have to show first that you're likely to succeed on the merits, second, that you're likely to suffer irreparable harm in the absence of preliminary relief, third, that the balance of equities, meaning the fairness factors, tip in your favor, and fourth, that an injunction is in the public's interest. In this case, the district court never reached the other factors. It decided the case solely on the basis of whether the plaintiffs were likely to succeed on the merits. So the Eighth Circuit reviewed the district court's holding that the coalition was not likely to succeed on the merits, and essentially they disagreed with the district court's opinion. First of all, under the Administrative Procedure Act, a reviewing court can set aside an agency action if that agency action is arbitrary, capricious, and abuse of discretion, or otherwise not in accordance with the law. The court simply ensures that the agency has acted within the zone of reason, and in particular, has reasonably considered the relevant issues and reasonably explained the decision. The standard is pretty deferential to the agency, but in this case, the court applied the proper standard and went against the agency. The court explained that the decision is arbitrary and capricious if the agency has relied on factors that Congress has not intended to consider. So all of those factors that are listed in the rule are nowhere in either the National Firearms Act or the Gun Control Act. If the agency has entirely failed to consider an important aspect of the problem, offered an explanation for its decision that runs counter to the evidence before the agency, or is so impossible that it could not be described to a difference in view or a product of the agency's expertise, then it's an abuse of discretion and it's arbitrary and capricious. And they also say, look, an agency action is internally inconsistent and not reasonable and reasonably explained. Well, that also fits the arbitrary and capricious standard. So as I noted, the first step required examining whether the weapon was equipped with an accessory that provides a surface area that allows the weapon to be fired from the shoulder. Now, what do you notice about that term, a surface area? You know, is that a surface area the size of a pencil? A surface area the size of a quarter? A surface area the size of a softball? What is it? The coalition challenging this rule alleged that the step was arbitrary and capricious because the ATF refused to include more specifics on the minimum surface area required. They wanted to know, is it 1 inch, 4 inches, 10 inches? What is it? We need guidelines. And the Eighth Circuit agreed with them. The court noted that multiple commenters had asked the ATF to provide some indication of what amount of rear surface area would trigger the rule. In response, the ATF said it reasonably chose not to provide metrics because metrics would allow people to use them to circumvent the rule. They said they avoided bright-line rules subject to easy circumvention in favor of an undefined standard. Now think about that for a minute. An undefined standard? How do you conform your conduct to the law when the standard to which you're conforming is undefined? The court says the problem is the final rule doesn't explain how providing any amount of mathematical guidance, never mind bright-line mathematical rules, was likely to lead to circumvention of the rules. The ATF failed to create an identifiable metric that members of the public could use to assess whether their weapons fall within the final rule's definition of a rifle. And remember, if you guess wrong and you fail, and you have a pistol brace that the ATF believes is a short barrel rifle, you're going to jail. It's not a good situation to be in. And the Eighth Circuit made the right call here. The court said the lack of metrics is compounded by the ATF acknowledging that the majority of braces are going to be short-barreled rifles. And the ATF did not identify a single braced weapon with a surface area that would not allow the weapon to be shoulder-fired. But the first step was not really a first step at all. And then the court went after the fifth and sixth factors and decided that they also were just absolutely wrong. The fifth was how the people who designed the brace intended it to be used. And unfortunately, the ATF could take even the most innocent of statements on the manufacturer's website as an indication that it was encouraging an unlawful use, and it didn't have any standard by which to determine whether or not or how to evaluate innocent statements of design. And of course, the community use factor was even more amorphous. That basically says how do other people in the community use it. Well, essentially that says if other people use it wrong and use it as a short-barreled rifle, then everybody uses it as a short-barreled rifle, and as a result, nobody can have one. Well, that makes me responsible for someone else's unlawful use, and that also was not up to par for the Eighth Circuit. So the Eighth Circuit didn't grant the injunction. It sent it back to the North Dakota District Court to have them consider the final three factors of a preliminary injunction and grant a preliminary injunction if it deemed that that was the right answer. And whether the North Dakota court will do that, of course, is an open question. But the Fifth Circuit case has already gone to the point where it is a vacated rule, and so if the Fifth Circuit does not reverse that decision, then there's a good chance that it will go all the way up to the Supreme Court, much the way several other ATF cases have gone to the Supreme Court. Now, as I said, this is a law nerd opinion, but it's a very well written opinion and one that I thought you might find interesting. Well, we have reached the end of another video. I hope you enjoyed it. As always, I'd love to hear your thoughts on this. Did the court reach the right decision? Tell me what you think. I would love for you to give me a like on this video if you enjoyed it. And if you haven't already subscribed, well, I'd love for you to do that too. Sometimes when folks leave comments, they want them to be to me personally and not be seen by other folks. You can email me at the address above. It's right up there, aldewit7@gmail.com. So if you don't want to share something publicly, you can drop me a note there. One thing that I ask at the end of all these videos is that you make somebody else's day better today by doing a kindness. Doesn't have to be a big thing, just make somebody smile. So many of you have told me the wonderful things that you've done to help other people, and please know that that matters to me and that I appreciate what you're doing. I'll be back here at the beach tomorrow with another video. Until then, stay safe, stay legal, stay informed. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.